We do apologize for the break in transmission earlier on. The audio problem has been resolved, and joining me in studio is Mosiri Tsiane, lawyer with the South African Liberty Foundation as the chairperson. There's Fiso Mahlango and Professor Sipho Siepe, political analyst. Richard Chemely is a legal strategist joining us via Skype. Gentlemen, thanks so much for joining us. The question I was asking was that constitutionally, can this be done? There's no precedents there that we know of, where a president can be impeached by the Constitutional Court and also dissolve Parliament. Yeah. So is this flagging a dead horse? Well, my audio is back, thank goodness. It's a tough one to point out. But in the first place, Mr. Malema as a single individual cannot collapse Parliament. In the first place, he called for the removal of President Jacob Zuma, if not by a vote of no confidence. He was calling on the Speaker to remove or deal with the President, to discipline the President, failing which he's calling for the total collapse of the National Assembly, the House of Parliament, because it has failed to service South African citizens. So I voted in 2014 and so did he. How are his rights higher than mine, and how will he collapse the National Assembly? We live in a state, and this is a constitutional democracy, which means that as a state, the judiciary is not higher than the legislature is not higher than the cabinet, and vice versa. So one member of a political party, for instance, and not even the president, can wake up tomorrow and decide, well, we're not going to have a parliament in this country. That is essentially also saying that I can wake up tomorrow and say, well, we will not have any courtroom in this country. I'm deciding to collapse the Constitutional Court. It does not work that way. The reason it's called a National Assembly, it's because we are all nationally represented. All of us who voted give a mandate to the political parties to represent us. One member of one party cannot decide to close down a state organ. It's just political mudslinging. That cannot happen.
Yeah, I mean, you talk about the electoral process, and that in itself is part of the concessions of the constitution or democracy that we enjoy. So if the Constitutional Court were then to impeach or dissolve the National Assembly, it means that whole process needs to be thrown out as well, Professor Siep.
Well, this is one case where I don't think there'll be people who are going to try to oppose him. Actually, I think it will provide a political education that will emerge from the Constitutional Court, and where the court would actually begin to explain concepts of separation of powers. But Sviso was also raising a very important issue about what democracy is all about. The fact that you think in a particular way and you want to see certain results and outcomes, you should know that that is your right to express those, but you must also respect that there may be other people who hold a different view. But what we have here, we seem to be having a grouping that says it's our way or the highway. And that can never be considered to be democratic or even constitutional. So on the matter of Parliament, yes, the court had ruled and had expressed itself on President Zuma. But what it does is to comment on the legal process and to provide a legal remedy. But the Constitution is very clear that once the court has done that, the removal or the sanction on the president is a province of Parliament. And it is very clear on what needs to be done. And what is interesting, it says, you can actually remove the president when you no longer have confidence. And it says you may also remove the president or when the president had breached or is shown to be incapable or is guilty of gross misconduct. But the word that is used there is may. It does not make it automatic. But what the Constitution says the removal is a political process. So that is very clear, and that's what Mr. Malema must understand. And what is problematic is to understand that the political process, it's also about numbers. because it's about the support that you enjoy. When you say they are public representatives, and yes, you expect them that there'll be respect for the rule of law, there'll be respect for the constitution, but ultimately, a political process involves parties voting. And in this case, it's unfortunate. So Mr. Malema's recourse really will be to continue to raise issues and to wait for elections where he might be elected. But we know that he has raised a lot of noise, but the party has not done well. Maybe next time it will do well. But I don't think this foray into rushing to the Constitutional Court, I foresee a situation where at least the Constitutional Court will make it much clearer for everybody about the notion of separation of powers.
Yeah. And you can correct me here, Ms. Siri, from a legal perspective, in that I think the term is double jeopardy, in the sense that, you know, when you've been found guilty of a particular crime or a transgression, you cannot be charged for it, and especially when there has been remedial action. As we labeled what the Constitutional Court had said Jacob Zuma must do, the Treasury ought to do, the amount that needs to be paid back, all of that is done and dusted, and yet we still hold on to these matters.
True that, but I think what we need to acknowledge is that we're not dealing really with a legal matter here, which is common knowledge to everybody that there is a separation of power. The parliament will make the law, the other one will review the law or just go through it and make sure that it's implemented properly. We all know that it's there in the Constitution. Every South African know about it. But here it's a pure political game that's been played to undermine furthermore the president. It's as if once you have dealt with the Nkandla issue, I say, no, we could not topple the president through this process. Let's look for an alternative matter that we could be. And here you are dealing with, one can say that as half, we say that is delinquency. You're dealing with somebody who's been naughty in the parliament, who've made noise, disrupted parliament. When you failed in that process, what do? You now go and you rush to court. Look for another reasons that can have South Africa concentrating or looking into a different level of engagement in a different platform. But truth be told, if you want to lead South Africa, convince majority of South Africans, let them go and vote for you. Do not hold this country at ransom. We're interested in progress ourselves. We're interested in the progress of South Africa. We're interested in upliftment of black business in particular. We're interested in the upliftment of black people in general. But what is that got to do? The EFF, when it came in, it promised people during its initiation process, it promised people land, it promised people all those sort of things, that people will earn huge salaries. That is no longer the core function, or rather the core important aspect of the EFF. Now it's looking into other aspects. In actual fact, it's now dancing to the tune of the DA, their coalition. It's doing the same thing. If you can't beat them in parliament, rather go and have them argue all the matters in the court. That's what we're seeing here. But surely, it's a battle lost, even on initiation process or just at the beginning. It's a battle lost. Legally, there is no ground for this.
All right, let's get the view from Richard Chamley, is a legal strategist. Richard, thanks so much for joining us this evening. And just your view on the action taken by the EFF dragging Parliament to the Constitutional Court, demanding that they dissolve a Parliament and impeach President Jacob Zuma.
Well, I'm excited because this is uncharted territory, and it will be interesting to see what the court comes out and says. We can almost guarantee that the court is going to bring up separation of power and try and pass the back to Parliament. But there is some precedent across the years of Parliament ordering of the court ordering Parliament to act in certain ways. For example, one of your previous guests mentioned that they should go to the ballot box and the people should vote in the ballot box. But that's not always the case, because there are sort of minority protections. And a good example of this would be in 2005, when same-sex marriage came to the fore. And it went all the way to the Constitutional Court. There was a judgment called Fourie, and the Constitutional Court ordered that Parliament must remedy what's the problem in the legal sphere. Now, of course, that's not as stringent and serious and direct as ordering Parliament to discipline the president. But if there is a path for Malema and the EFF and any opposition really to go the legal route in disciplining the president and possibly impeaching the president, there is soft precedent for them to do that. Although, that being said, I should qualify by saying it's going to be an incredibly arduous and difficult route for them.
Yeah, actually, I think we should make a distinction between ordering the legislature to correct a law that is considered to be unconstitutional. Because what the court does, because it has to make sure that any conduct or any law that is not consistent with the Constitution, it begins to express itself on that matter. And when it does that, it assists parliamentarians, because parliamentarians are not lawyers. They may be lawmakers, but the issue of constitutionalism, even for judges, they get it wrong. But for them to say, and the court has found against ministers, but nowhere has the court suggested that a minister must be expelled or MEC must be expelled, because they understand that that is now a political process. What they do on a daily, every week, the courts come up with judgments against the government, but they do not go to an extra mile of saying this person must be dismissed, because they leave a political process to the political process. And I think what is being asked here is that the court must now assume to a political or ask for a political action. And also, it's also not true. You need to also understand that what has also happened. The DA, as well as EFF and other parties, have exercised their right in terms of the Constitution to try to remove the president. The fact that they've lost, they will try. This is about trying another forum. But the court must also be very careful about allowing itself to be abused. And this is where the courts might actually stand to be abused. And the former Chief Justice actually has warned against that even Dennis Davis had actually raised the issue about the courts getting involved in the political process, because if they do that, they'll earn no respect. Because people in this country are not stupid, or anywhere in the world. Where judges become political, they will actually tell those judges where to get off.
Your response, Musiri, on Richard saying that there could be a soft precedence with the EFF dragging Parliament to court?
No, I would reiterate what the Prof has just said. That, even if you would say that these are the judgments that are standing, but these judgments are not in essence dictating to Parliament what Parliament must do on this other aspect. It's just saying that you do not comply with the Constitution. Comply with the Constitution. This is what the Constitution says. You need to comply with the Constitution and then implement what is required of you. It's not dictating. Otherwise, in essence, what would be is that we would rather go to court and ask who should be our next president. Then court will then determine to us who the next president of South Africa is, without having us to go and vote for the country's president. That's it. It's not. The Constitution is there to check the imbalances that are there. The courts, actually, what I'm saying is that the courts are there to check the imbalances that might be, that are infringing on the Constitution. But it's not a dictator to say that this is what the court must do, this is how the court must. The Parliament remain as it is. It's sovereign its own way. Yes.
Yeah, and I mean the Concord would have to use the judgment on the Nkandla and other matters that came out of that, the public protectors, remedial actions being binding, etc., to satisfy the current case, if you will, that the EFF is bringing to dissolve Parliament. And I don't know if it's likely that they will find that, indeed, there is an opportunity to implement or to dissolve Parliament based on the preamble of their previous order.
Well, if that happens, I will call to dissolve the judiciary, because they will be in effect saying that my vote was in vain. I voted, and if I voted for the Freedom Front Plus and they have 2 seats in Parliament, I put them in those seats. And I have given them a mandate to represent me. When the Freedom Front Plus speaks in Parliament, it represents I as a citizen, as a voter of this country. Should the High Court, should the judiciary overthrow those people or throw them out or close down Parliament, they are diminishing my rights as a citizen, because I have asked my party to represent me. if that happens, I'll really call for then the judiciary to fall. We must be respected as voters. This is an electoral system. The voting system is fair and independent. We all vote. If a political party, a member of a political party, does not prefer the results, it's very simple. It's a democratic constitution. You wait for the electoral commission, you wait for the election date, you cast your ballot, and then you come on top. But when people have voted, allow those leaders to represent them. In the same way, we cannot have the Freedom Front Plus calling for the DA to fall, or even for the ANC attempting for the EFF to fall. If that was the reason, many people would have called for the EFF to fall a long time ago, because I wanted to hear the SONA. And I was in Cape Town in the National Assembly. But they were delaying my time because I wanted the president to address me as a citizen. So my rights were violated because people voted for the president to speak, and his delay in making the State of the Nation address, I felt was an infringement on my rights. So for that matter, we should be allowed to say we put leaders in that parliament. We should allow them to do their work.
All right, let's get a response from the legal strategist. Richard, just on what our panelists have been saying so far, that this is a test of the rights of voters who made their preferred choice to put a party in government and with their preferred president, that this should not be threatened by any political party that has different views.
Sure. Well, first of all, I mean, nothing in sections 2 to 36 of the Constitution guarantee a right to listen to the SONA. And also, you do get to listen to the SONA even if it's reasonably delayed. So if there was such a right, you would get it. But what's interesting here is that the Constitution allows for Parliament to dissolve itself. There's some conditions. It has to be a majority vote, and it has to Parliament has to have sat for 3 years in Section 50. But the difficulty with that is that once that vote has been taken, the president has to dissolve Parliament himself. So if that happens, then there will be a far greater grounding for Parliament to be able, or for any party to be able to take the president to court to compel him to dissolve Parliament. But at this point, it seems like it's too premature, and that there's some political grandstanding taking place. There's far more political avenues for our politicians and our parliamentarians to explore before they approach the court. And it's dangerous to approach the court at this point, because you bring the court into the legal or into the political realm, which is a place that the court should try and avoid.
Yeah, just on the point of the voters' rights as well, in that 11 million South Africans voted in the local elections in favor of the ANC, that they're still the governing party. And what Sfiso was saying is that by now threatening to dissolve Parliament, or rather dragging Parliament to the Constitutional Court, it is a violation of that voters' right and preference.
Well, no, I mean, anyone can drag anyone to court, and it's up to the court if they want to hear it or not, and what for the court to decide. I mean, you have those rights as well as a citizen and as a member of Parliament in the Constitution. And, you know, you've got access to the courts. But I just think it's folly and stupid to go to the courts at this point, even though there may be a really, really small chance of some minor success. There's greater chances of success by exploring the current political and legislative avenues rather than the judicial ones.
All right, Richard Shumali, thanks so much. Legal strategist speaking to us via Skype. But just a final comments from you, saying that even if there is a small chance, we have bigger issues to worry about in this country, and it's very unlikely. Unlikely that the Constitutional Court would make any pronouncement on the dissolution of Parliament.
Yeah, it's true. I mean, all we're interested in South Africa is how do we get South Africa move forward? How do we make sure that we respect our president? Majority of people have spoken. How do we make sure that he leads us in a way that you know, from where we were from 1994, South Africa gets better? That's all we're interested in. Now, this kind of politicizing each and every little issue, we're having people even politicizing legalities of certain aspects. It's not taking us anywhere else. In actual fact, you're delaying our progress. We should be moving forward. You are just holding us here. You can hold us for an hour. You want to hold us back furthermore. This is not moving South Africa forward.
Yeah. The last point I want to say is that democracy is about the people. And no judiciary should be allowed to undermine the people. And if they do that, then what we have is a judicial tyranny. And what it will call for is exactly what Sfiso was saying, that we should actually call for it to fall if it is going to undermine the will of the people. What we want the judiciary to do is simply to assist in the interpretation of the law and also come up with fair and reasonable sentences where it has to, where those should be there. But for them to start assuming that they are politicians, they actually will be treated like politicians and they'll bring a disrepute to the court. So I think part of the problem is that we have had acceptable judges who have almost strayed into the politics. This is why some people have argued that some of the judges are overreaching. And the point of overreaching is something that we must always guard against. Freedom means eternal vigilance, not only against the politicians, but also against anybody, including the judges.
Are the EFF provocateurs trying to remain relevant, as some commentators have been saying, with this move?
Well, relevance is a necessary trait in party politics. But if anyone was to remove any member of parliament or a party, would definitely have to remove the EFF for the antics of last week. But people allow that because even they claim their rights. But I cannot, as any leader, claim that my rights are better than yours. I cannot assume that I have a better preference to the will of the people than you. As much as I expect to be treated with dignity, I must also do that for you. We must, however, emphasize that we must allow the judges, we must allow the courtrooms to exercise within their legal spectrum and not to drag them into the political periphery. Judges and the courtrooms must not allow themselves to be used as political dogs or as political tennis balls, or as we throw mud at each other. They should not be there. However, should they exude their mark and enter the political terrain, we will treat them as we treat politicians, and that's a dangerous place for a judge to be in.
All right, thank you so much, gentlemen. As always, a pleasure chatting to you. Mosiritsi Yane is an attorney, a lawyer rather, and South African Liberty Foundation chairperson, Sfiso Mahlangu, and Professor Sipho Siepe, political analyst. Richard Chamali is a legal strategist joining us via Skype. Again, much appreciated. We'll take a quick ad break, and Clive from Mativela Smith is up next with Biz Pulse.